Welcome to the Ports Garrison. Please like, subscribe, and share. Thank you. Greetings. Once again, welcome to the Ports Garrison. I am your host, Phil the Poet, and I hope I find you in the best of health. Now, today I have a wonderful, wonderful presentation for you, because I've known that my subscribers and viewers particularly love to listen to the thoughts and expressions of one Senator Damian Crawford. I haven't uploaded a video of him in a long time because he has been missing from the Senate for a while. I assume he has been taking care of family and business interests. So last sitting of the Senate, I think it was the 28th of July, he spoke to the whole issue of the changing of the Constitution to facilitate the change of the retirement age of the Auditor General and the Director of Public Prosecution. Now, he set it out in a very smooth, fluent way, so it's easy to be understood. And as always, he gives a different kind of viewpoint and a different take, a unique take on what is happening. He shows the rush the government was in to change the Constitution before the birth date of the DPP. He showed how the government had not made any plans. There was no planning, no advertisement of a vacancy, no interview, no effort was made to find anybody to replace the DPP, because it seems as if their only intent was to extend the age of retirement. And he labeled all of that as an issue of very poor governance. And the main thing of his presentation was to prove that the Constitution is really supreme. So this is about the supremacy of the Constitution. Now, I don't want to paraphrase or summarize for you, so I'm just going to sit back and let's watch the video together. Here, take a look at what the senator had to say.
Mr. Crawford, thank you very much, Mr. President. Well, I have no need to shout because I am at no heightened emotional state. I have analyzed the conversations over the last few days, the presentations in the lower house, and indeed the presentations in the upper house. But before I start my presentation, Mr. President, I'd like also to acknowledge former Speaker of the House. What is the correct term for a former Speaker of the House? Furniture. Thank you very much. Who is a person that I myself can say have been very kind to me personally. And I remember one conversation he was trying to advise me. He said, your duty is not to change everything you want to change, but to move it closer and don't die in your attempt. I'll never forget that conversation when an article about no handout came in the newspaper. Sir, I thank you, and I acknowledge as well your daughter, sir, and Member of Parliament, Ms. Charles, for her presence, and whatever respect and gratitude I have to you, pass to all your children. So by extension, it is passed on. To our former colleague, Senator Campbell Rodriguez. Yes, I know I am so happy because I used to look and see your agreement over there. Now I have to focus this way to see your agreement in this case. But I am very happy to see you here today. Mr. President, I ask for your protection from Mr. President. Whenever there is a debate in the Senate, and I'll put it to you even in the lower house, there are many hurdles to cross before one reaches to agreement. One initial hurdle is if the proposal abides by the Constitution. But that is not the only hurdle. My good friend, Senator Floyd Morris, state that he is not prepared to be the judge on that matter. But it's clear that there's a difference in opinion on whether it crosses the first hurdle of being constitutionally correct. But if it was that we stopped only at the constitutionality of the bills before us, then many would not need a debate. Because the majority of bills that we debate and accept, reject, or quarrel about is not perceived by any side to be in contravention of the Constitution. So therefore, if there is indeed, and there clearly is by legal trained and legal luminaries, on this side, Senator Donna Scott Motley has said she believes there may be. On that side, Senator Ransford Braham has said he believes there may not be. And there is an appropriate space for that conversation and that deliberation. And Senator Scott Motley said the courts, and correctly Senator Don Webby said it is her right and our right and the nation's right to seek an answer if there's a difference in opinion. However, the debate don't stop there. The debate actually starts there because there are multiple other hurdles, as is what is being done, why it's being done, and how it's being done. Therefore, my first point of departure with Senator Golding Campbell is the treatment of the Constitution and the things within the Constitution. Every letter, every word, every sentence, every comma is important. And because of the importance of the Constitution, is even more important than some of the other bills that we have looked at in here. Indeed, while I served in the lower house, it is in this house that I knew the vast importance of a simple comma, or a term shall or may. Have we not had extensive debates and indeed recommended changes to a single word in bills less important than the Constitution? So therefore, any change, if it's even a comma, deserves a treatment that recommends to the nation and its citizens that the Constitution is very, very, very important. What therefore is the reason for, is it chagrin, for consternation, for concern, is it seems to me the treatment of the Constitution in this particular change belies the importance that the Constitution should have and creates precedent that any Jamaican should be concerned about. Indeed, Senator Bunting, if an act happens on its own, it may receive less weight than it is a part of a trend. Most mathematicians and scientists will say that a number by itself has less answers than a number as a part of a trend. We have seen in this country, in recent times, as perceived and created by this government, multiplicity of acts that could be perceived and that has been found to be treating the Constitution that as less important than it should be treated. The grave concern of this particular one, therefore, is because it is a continuance of what we had recognized even more recently as the act of implementing new states of emergency to avoid coming to the Parliament for its extension. That could not have been the intent, or as Senator Webby said, the spirit of the Constitution, that to avoid the Parliament, you do a new one every 14 days as versus come for an extension and risk a debate. We have seen where the Justice Sykes would have been asked or considered to have, what was it, a probation period as Chief Justice. We have seen where senators were asked to sign letters committing them to agreement. Well, undated only means the length of their commitment into infinity. But they could have signed one for just this debate. And then this debate moves on. In fact, if I should go back to the state of emergency in this house, I think it was the leader said, thank the Lord we will not consider that recommendation. And then did it. No, I can't call Uncle Randy. I'm biased in this. I'm biased. And knowing him, he still believes it to be true. So this particular one, on the what, and the why, and the how, is creating concern because I'm not saying if it can be done. I'm not an authority in the law. What I'm debating is if it should be done. And if it should be done in this way. What are some of the considerations that we have before us? One of which is that the Constitution is the supreme law. And indeed, if there is a discrepancy between another law and the Constitution, it is the another law that is supposed to be corrected. What we have is a recommendation that the discrepancy's direction of correction is to correct the Constitution. Now, this might be in the case. No, you have to give me a chance. Yes, because other than that, we won't leave here. Huh? And he's my neighbor, I know. But what I'm saying is that the precedent of saying, of thinking, of acting in a way that the Minister of Justice says the correction of the Constitution is based on its contravention of the Pensions Act. Let us look then. And I quote, the proposed amendment, if amendment is change, correction, to the Constitution will allow for the expansion of the term of service for 60 years, from 60 years to 65 years, thereby addressing the inconsistencies that currently exist between the two pieces of legislation and by extension creating a more equitable playing field for all, unquote. So, well, I'm saying that by practice, that by precedent, that by rule, we should be careful of the direction of correction, and people therefore are concerned. I also must suggest to you that and I've been watching some cases now on YouTube, so I'm a YouTube lawyer now. And yeah, I'm a lawyer, village lawyer. But I've seen where they're saying some cases don't have the gun, don't have the nothing, but it is built by just different things coming together. What the circumstantial evidence. And then the judge, you watch a case them to lie me, yeah? Oh, Tom is teaching a law. And the jury should put all those circumstantial evidence together and use logic to make a determination. Indeed, I have no axe to grind. I think I've met the DPP once. But circumstantial evidence suggests that there seems to be a correlation with the date of the end of the current DPP's contract and the act and rush to ensure that the last day of Parliament before that date treats with a matter that for some reason couldn't wait on all the other changes that is coming, that for some reason couldn't wait on Parliament coming back in, but also that with the date of the end of the DPP's contract being September 2023, there has been no internal nor external effort to find a new DPP. So therefore, if the government had intended that the September 2023 meant something for the office of the DPP, then the government would have mistreated that intention, having not made no attempt, no advertisement, no interview, no nothing. And to my knowledge, no succession planning, as Senator Dunwebby said. And to my knowledge, you can't have an acting DPP. Senator Scott Matley, am I correct that you can't have an acting DPP? You can't have an acting DPP. So maybe the government was intending to go through a process of acting DPP. Yes, that never company. The algorithms never carry that one. But maybe the government had intended, in spite of the fact that the government gave an extension 3 years ago to end in September, and knew that that extension would have been up. Not only did they give 3, they give 3 even though available to them was 5. They said 3. And the GG. And not only was 3 agreed to, a basis was presented by the government. That basis was 2 very important cases, one of which was the Klansman case, and the other one, Wilson. Both have been completed. And not only completed, none was led by the current DPP. In fact, they are being led by people who are still there and who don't know in year 63. And that's an important point. Because if it is that we're going to change the Constitution, it must be that we find that the needs of the society or the interest of justice is about to be served. That desperate actions are for desperate measures for desperate situations. What is the desperation? What is the desperation that we have observed that there can be no delay in the correction of something such as the age of retirement, when the only real emergency is the age of the current holder of the office of the DPP? What therefore? No one else has created to me what is the emergency. What's the emergency why October is too late, even though this reality existed for 3 years? The Pension Act has been established for 3 years, which means that the discrepancy has been there for 36 months. 6 years? The change was 2017? So the discrepancy existed for 6 years? For 72 months? 72? Yes. I was going to give them the number of days, but it was risky. It was risky. Yes, yes, I have some calculator over there. What has caused for we to be called back to Parliament? For all the quarrels to be ignored? For the consultation to be unnecessary? What's the emergency? And also, why would we put an office so important into not only disrepute, but to contravene what is one of the basic rules of justice, that it must not only be done, but it must be seen, perceived, believed to be done? We have had, we're not going to law school, But in this house today, two members of that side have accused the government of being an enemy of the DPP. There was one article, why Mark Golden, what is his issue, or something like that. This is the person, the office, that will decide on who to carry to court, who not to carry to court. Now the public is left with the unfortunate possibility, that they are going to analyze decisions of the office by who is an enemy and who is a friend. Instead of in a method as proposed by Senator Scott Martin.
Sorry, Senator, just 1 minute, please. 1 minute.
Yes, sir.
I'm sorry, members. I just wanted to acknowledge, and I'm doing this because I think she may leave. Just wanted to acknowledge the presence of Mrs. Lorna Golden, wife of former Prime Minister Bruce Golden and aunt of our own Senator Sherry Golden Campbell. Welcome, Mrs. Golden. And I understand that you were also helping Senator Morris in St. Mary with his recent unsuccessful endeavor. But there's always another time, Senator Morris, so don't be disheartened. Sorry about that. Sorry about that, Senator.
Yes, no problem, sir. And I too would like to welcome and acknowledge also other members of the Golden family who clearly were here to support Senator Golden Campbell. And unfortunately, she wasn't able to do her presentation. Yes, so what is the emergency why they had to cancel Senator Golden Campbell's presentation? Nobody has. So, I said to you, therefore, that the office of the DPP, first of all, the Constitution is not an ordinary law. It's not an ordinary document. And no matter what is the level of the sentence or the section, should be treated lightly, none at all. But the office of the DPP is also not an ordinary office. And so therefore the treatment of that should also be handled in a particular way. This is not the first that we have been having this rush. I remember when there was the Road Traffic Act, and it was a straight rush. I remember my colleague senator on many occasions had to ask that his disability be considered and time be given for him to review. This is not the first that these things are coming. And so therefore, what we're asking is that this not be that treatment. There's also, Mr. President, a suggestion that there was no consultation with the DPP and no consultation with the Attorney General about these extensions, the office of the DPP. So not only a breach, but they don't have any commitment that September means anything for extension. Because if there was no conversation or consultation, then maybe the current DPP is hell-bent on leaving in September. And it shows the health state, we call it the chaka-chaka management of the affairs of the country. A person will hold the office, and the office itself has not been consulted. But let us look on the office as though we can, but should we? I read earlier that more than 50% of the persons currently serving as prosecutors are less than 5 years of experience. Now, not only that's the case, But we must ask ourselves, what will be the impact of extending this period to where the probability of growth is so reduced that any real ambitious person may perceive that office not to be a long-term stop. And if those people perceive the office not to be a long-term stop, then what would be the level of turnover? And how will that affect our cases and the operations of the DPP? All of this is reasons for consultation. All of this is reasons for conversation, because there is an established thing about satisfaction with work effort. It is remuneration, salary, growth, and satisfaction with effort, and it's divided by prior effort, current effort, and risk. We know from just recently that their remuneration is not nothing that they're wonderful and satisfied about. Just recently, didn't that office senator had some action and some concerns? Yes. And that isn't being given priority. That isn't given priority. When the vast majority, don't they, 63. But that is not the priority. There was also some concern about how senior members have not been considered, have not been trained, have not been organized so that they can eventually take the position. Senior members, I think that I read earlier that there's 5 of high qualification. So there is no question that we have persons who are capable and able. And so that is why, if it is not a conversation about the person, then it don't have to be today. It can be October 2024. Because 7 years have passed, we can give 2 more. Whenever the house is reopened. So therefore, this effort that even the minister said no consultation was had. When lesser laws have been bragged about in this house, about the longevity of consultation. But for the Constitution, the minister himself said no consultation, not even with the areas that are of concern. So rushed it was that 2 ministers are now at quarrel as to who had it and who didn't have it. Who did it and who didn't did it. And none of those 2 is the person given the responsibility for constitutional change. So the 2 in quarrel is now being refereed by the one who should have been responsible. What's the reason for that haste? And what's the treatment for the Constitution? So, sir, if good governance is to be considered, it suggests that a precedent of flippant treatment of any section of the Constitution must be resisted and cannot be tolerated. It is that precedent that I am concerned about. And it is the trends that make that precedent seem to be likely to be continued that must be resisted, and that we on this side are resisting. So, belittling it to say consultation with the leader. Consultation with the leader as a citizen, because there should be consultation with the citizenry. For such an important office. And for any constitutional matter. So it's not just, oh, they never spoke to the opposition party. It is the treatment of something so important. That is why we need back civics in school. Civics for young Jamaicans. Because in the United States, where there is broad commitment to the Constitution, where the people say, my rights, this would never have been allowed, will never been facilitated. So while that side may have to act in unison, I know there are many that feels that a document so important and a precedent so risky should not be allowed to move forward. Thank you, Mr. President.
Now, I surely found it rather interesting the way he brought his points across and the way he set his argument out. Now, I am thinking that most of you would have also enjoyed this presentation. I want to encourage you to tell me in the comment section what you disagreed with, what you agreed with, and just to share your general overall comments on the whole issue. Now, please do so in the comment section, and then we'll have a discussion on it. Now, until next time, as always, I want to thank you for your support. Thank you for watching. As always, I ask you to like and to share the video. And until next time, when something else stirs my thoughts, I want to wish the universe, all of the universe blessings on you and your endeavors. As always, it's manners and enough respects. One love. Thanks for watching.